Right now on the Daily Debrief, opening statements in the trial of a crime scene investigator accused of murdering a former police officer. And two verdicts in other cases. The first in Florida, where a concealed carry permit holder shot and killed another man after a parking lot altercation. Is it self-defense? The other in Tennessee, where a defendant may face trial again for shooting and killing a man who he accused of molesting his girlfriend. The Daily Debrief recaps the day in court. It's Monday, August 26th.
Welcome to the Debrief, everybody. Glad you're with us. Jessica Ramirez, Anthony Pope, along watching our three trials tonight. Let's begin with the Florida prosecution of a former crime scene fighter who now finds herself on the other side of the law. Ashley MacArthur is a former crime scene technician, in fact, accused of murdering former police officer turned private investigator Taylor Wright. Wright's body turned up on property owned by the defendant's family, but MacArthur says she is not the killer. Authorities argue the motive for the killings is money. The victim put $34,000 in the defendant's bank account, and authorities say the defendant spent it without permission. During opening statements, the state tried to convince jurors that the evidence to come would point to a motive.
You will see those text messages, and the reason they're important is because you will see the pressure that Taylor Wright was putting on Ashley MacArthur to get this money. And the reason that matters is because the money was gone. Ashley MacArthur had spent it. Again, on September 7th, Taylor sent a message to this defendant. They could potentially put me in jail if I don't pay the child support like today. September 7th, text message from Taylor to the defendant. Please don't be late. They are going to put me in jail if I don't make that deposit today. Later that same day as that text, on September 7th, Taylor was at a restaurant called Twin Peaks over on Bayou Boulevard with her girlfriend. And as I explained to you in jury selection, Taylor had previously been married to a man. They had a child together. But at the time of this incident, she was dating a lady named Cassandra Waller. Friday, September 8th, 2017 is the last day that Taylor Wright is known to be alive. She was with this defendant.
The defense said the state just doesn't have enough evidence to point to Ashley MacArthur, and maybe there should even be other suspects.
There is no question that what happened to Taylor Wright is a tragedy. No one in this courtroom is going to dispute that. On October 19, 2017, Taylor Wright's body was found in a shallow grave off a fence line on the Britt family farm with a gunshot wound to the back of her head. Now, during this trial, there will be no evidence introduced showing you exactly when and where Taylor Wright was killed. You see, recently, Taylor Wright had gone through a contentious divorce with her ex-husband, Jeff Wright. And in the summer of 2017, things were amped up between Jeff Wright and Taylor Wright. Mr. Wright was alleging that Taylor Wright had recently taken somewhere in the neighborhood of $100,000 from a joint account. And Mr. Wright was fighting to try to get this money back from Taylor Wright. According to Mr. Wright, he's going to tell you that Taylor Wright is making this extremely difficult to deal with this money. Mr. Wright is having to resort to taking Taylor Wright back to court to deal with this money. In fact, you will see that on September 7th, 2017, a Thursday, there was a hearing scheduled in Okaloosa County to deal with this money issue between Jeff Wright and Taylor Wright. And this is just a day or two before Taylor Wright stops communicating with people.
Two attorneys joining us tonight, as I said off the top of the broadcast, Jessica Ramirez, Anthony Pope. So Jessica, let me start with you. Is $34,000 enough of a motive for the state to get to that top charge in this case? It's not a lot of money, and to say that there's premeditated murder because of $34,000?
I think that any amount could be a motive, and $34,000 is a lot of money. It depends who you're asking, but absolutely I think it's a motive. And she has a lover that she was buying things for on a monthly basis that we've heard about, and I'm sure we're going to hear more about. So I think that, yes, the $34,000 is a motive.
But Anthony, this always seems to be the fallback motive prosecutors look for. If they can't find another motive, it has to have been money. We see this in case after case after case here. Is there enough evidence to try to make it stick here?
Not by itself, certainly. The $34,000 isn't a lot of money, or enough that you would think somebody's going to put a bullet in the back of someone's head, especially because the money's already spent. So it's not like she's trying to hide it. It's already spent. So what's the worst that's going to happen? You're going to sue me for it? You're going to call the authorities, but I'm going to take the risk of putting a bullet in your head for $34,000? There has to be more than just the $34,000 for a conviction.
You're speaking like the defense attorney, so Jessica, I'll throw it back over to you here. The defense saying, oh, you know, look, police, you should have looked a little bit wider. You should have cast a wider net here in this case. There were other people that had money issues, even bigger money issues than just these particular people.
And I think that they're going to try to do that, but I think that the fact that the cell phone towers had her placed at the farm where the body was located, that's really compelling argument, aside from money argument. I think once they place her, the cell phone, the body there, I think that's compelling enough.
So Anthony, when we add it all up here, at the end of the day, we've got people who are law enforcement officers, crime scene techs, you know, people who are supposed to be working with prosecutors' offices, who are now, at least in the defendant's case, sitting here accused, and then one is a victim. I mean, talk about a strange factual scenario here.
Yeah, it is. And again, the defense attorney went over things that I would have been a little bit more emphatic about and more dramatic about. I think that demonstrative evidence is very important in an opening and a closing statement to show this jury exactly what they don't have. All of these resources, and nobody could come up with anything other than this motive of $34,000 with two women that have been living together for a while, want to go into business. It's not so unusual that one could be spending the money and the other one not spending the money. You got a contentious divorce. You have a woman, a victim, who's already deceived or tried to deceive the court, her husband. So, you know, she doesn't have all clean hands. So, you know, they have to, the jury, look at it and say, well, if I don't have any direct evidence, I have no videos, I have no fingerprints, I have no DNA, can I be comfortable going home at night and putting this person in jail for the rest of their life? That's a hard sell, perhaps. Depends how the witnesses deal with it, you know?
Yeah, most people want to believe that officers of the law are upholding the law, not breaking it, and it's tough to get to the other side. Look, I know sometimes they misbehave, though, so we're going to watch this case closely. A guilty verdict late Friday night in the case of a black victim shot and killed by a white defendant after a fight involving a parking space.
It is set for trial today is State of Florida versus Michael Draco.
Michael Draco was accused of manslaughter with a firearm for gunning down Marquise McLaughlin. Prosecutors said this surveillance video showed Draco confronting the victim's girlfriend for parking in a handicapped space without a permit. During the confrontation, the victim walked outside and shoved Draco to the ground. Draco, a concealed carry permit holder, pulled his gun. He told police the victim kept coming toward him, so he fired and claimed self-defense. But the footage showed the victim turning away from the defendant just before reacting to being shot. Here was the verdict.
As to the charge of manslaughter, we, the jury, find as follows as to the defendant in this case. The defendant is guilty of manslaughter as charged.
Draco's defense team worked for free. Attorney Bryant Camerino joined us on the Law&Crime Network.
I was shocked, of course, disappointed. Obviously, we respect the verdict, but it was also expected in the sense that when the prior bad acts or the Williams rule evidence came in, we kind of expected that we were off to a bad start. We anticipate to appeal on that issue. We felt that that was made a feature of the trial, and I believe it unduly prejudiced the jury to the point where they came back with a guilty verdict. But overall, we were afraid that if he got up there, that they were going to twist his words, make him out to be a bad guy, and so we opted not to call him to the witness stand. He gave an interview to law enforcement. They twisted his interview, which we expected that they were going to do, meaning the state. We figured, you know, Michael, if you take that stand, no matter what you say, they're going to twist your words against you. So let the tape speak for itself, and it did. And you know, the danger was that the judge would not have allowed the the self-defense instruction go forward to the jury. So there was a point there that had the judge not allowed the self-defense instruction, that we would have put Michael on the stand. But because he let it in, then we didn't have to put him on the stand. He wasn't here to stand for gun rights, Second Amendment. We as lawyers, we made that the issue during the trial. He was very remorseful. Going back, he would not have done it again. But again, hindsight's 20/20, and so he feels that unfortunately it happened, and that obviously he wants us to appeal the verdict, but he respects the jury's verdict. It's just a difficult situation.
During closing arguments, the prosecution said the defendant had absolutely no right to pull the trigger.
But here's the million-dollar question you need to ask yourself. Was this defendant justified in shooting a man that came out to protect his family while he's retreating, while he was unarmed? Did he reasonably believe, as Marquise McLaughlin was backing up and turning to go into the store, that he was about to die? Because that's what that instruction says. Did the defendant reasonably believe he was going to die as Michael McLaughlin backs away when that firearm comes out? Did the defendant reasonably believe he was about to suffer great bodily harm? Was he about to be beaten to a pulp as Michael McLaughlin went backwards? No matter what, can't shoot a retreating, unarmed man. Does not matter if you believe in the shove, you don't believe in the shove. It does not matter. You can't shoot an unarmed, retreating man regardless. Marquise is protecting his family. Again, it doesn't matter if you feel it was a good shove or a bad shove. That's not an issue in the case. It's not. It doesn't matter that Brittany parked in that spot. She shouldn't have, but that's not an issue in the case. Really, what this is about is his behaviors. That's it.
That's the state side of things. The defense, meanwhile, said Michael Drake had every right to complain about the victim's girlfriend's parking job and had every right to pull the trigger.
Your right to stay alive is the most fundamental and natural right a person has. We live, unfortunately, in dangerous times in this country. It's unfortunate that people find the need to have to carry firearms to protect themselves. But it is the will of the people that be permitted. You have a right to speak if someone does something that's offensive. And that's what Mr. Drake did. He exercised one of his fundamental constitutional rights to talk to someone who was violating the law by parking in a handicapped space. Now, you may think that that's a minor issue, it's not really that important, but to some people that's extremely important. You watch Mr. Drake in this afterward, go ahead and continue. As Mr. McLaughlin goes back into the store, he keeps his firearm trained on him because he doesn't know if he's a continuous threat, which is what one would expect when you're trying to see if there's a threat. As soon as the threat is over, he puts the firearm down. This is not a vigilante. This is a person who was viciously attacked and responded appropriately.
The prosecution was obvious about the political ramifications of this case during a rebuttal, but nonetheless tried to point the jury toward the specific facts the state believed were necessary for a verdict.
The Second Amendment. It's been around forever. It's a great thing, fine. The NRA, fine. But carrying a concealed weapon, fine. But just because it's there doesn't mean everybody should be involved in that. That fella right there had no business ever having a gun. No business. That's what this is all about. He had no business operating a firearm. He didn't know what he was doing. And they want you to say, well, he might have not received the proper training. Or, okay, he didn't know exactly what the 21-foot rule is. Well, you killed somebody because of the 21-foot rule. You should know what it is, because you took the life of another human being. Isn't the value of human life more important than that? Think about it. Think about it. If you're going to operate a firearm, if you're going to have a carrying concealed weapon permit, and not just have that permit, but carry a sidearm around on you every minute of the day, you better know how to use it, when to use it, and when not to use it. You don't put yourself in the position that he puts himself in.
Let's back up now, listen to some of the testimony from earlier in the case. The prosecution experts said the victim had the drug MDMA, or ecstasy, in his system. Now, the state's experts said the victim was behaving normally in the video we've shown you, and that the drug would have resulted in empathy or well-being, not aggression. That was the state side. But the defense hired an expert who disagreed and even went further.
We saw that Mr. McLaughlin went outside and left his child behind with strangers in the store. Displayed instant physical and behavioral aggression without provocation. Within 8 to 10 steps out the front door, there was no dialogue with Ms. Jacobs to discern who started, what was being said, what the nature and intensity was. There was no discussion with Mr. Drake either. There was just a physical assault. After that, there was also no assessment of the situation for additional risk factors. Were there more than one person around the car? Were there other risk factors? Also, the assault and the individual without consideration for the family and the children. After having been shot, he left the children and his girlfriend in the car, and went back into the facility. So I do appreciate he had been shot and was doing some type of retreat, but if the intent was to protect Brittany and the children, it was an opposite effect of what you would expect.
And still ahead here on The Debrief, we're back with the panel to argue whether the shooting of Marquise McLaughlin was self-defense or a crime. Plus, the strange verdict in the case of a Tennessee man who testified that he pulled the trigger to save his girlfriend you just saw from being molested by the victim you just saw. We're back in just a moment. Let's discuss the Drake verdict right now. Tonight, attorney Jessica Ramirez and Anthony Pope. Jessica, I'll start with you. Is this the right answer to this case?
Absolutely, it's the right answer. I have to tell you, I agree with the prosecutor at the end where he says this is a man that shouldn't have been carrying a weapon in the first place. Absolutely not. I think that he was the aggressor here. I think that clearly, I mean, we saw it on video, he was pushed. There was no vicious beating here. And when the victim was trying to retreat, he shot him. So absolutely, it was the right verdict.
Has anybody ever heard, Anthony, of a toxicologist commenting on the victim abandoning his family? How is that in the purview of a toxicologist to comment on?
It isn't. It should have been inadmissible, but there wasn't an objection, so it came in without any challenge. But I agree with Jessica. I think the verdict was right. Frankly, if this was in New York and New Jersey, that conduct, that would have been aggravated manslaughter. He got away easy with manslaughter. Because it's depraved indifference to the value of human life. That man, he pushed them, it was wrong, but he was walking away. There was no justification whatsoever for it.
Different state with different laws, concealed carry changes things and whatnot.
You know, Florida, they're liberal with that.
It's different. A jury acquittal and a hung jury, both of those came down in the case of a young Tennessee man accused of killing an older man who he claims molested his girlfriend. 25-year-old Sean Foley admits gunning down 44-year-old Jimmy Shelton, but Foley says he did it out of self-defense. Foley says Shelton attacked him after learning Foley recorded evidence of Shelton engaging in a sex act with Foley's own girlfriend. The jury acquitted Foley of premeditated first-degree murder, but hung on a lesser charge.
With State versus Sean Patrick Foley, as to the count of guilty of first-degree murder of Jimmy Shelton, has the jury reached a unanimous verdict as to that count?
Yes.
Okay, and what is your verdict as to that count?
Not guilty.
As to the lesser included charge of second-degree murder, has the jury reached a unanimous verdict?
No, ma'am.
And as the jury foreperson, do you believe you are hopelessly deadlocked as to the count of second-degree murder?
I do believe we are.
The jury, having returned a unanimous verdict of not guilty to premeditated first-degree murder, and then having reported unanimously that they are unable to reach a decision as to the count of second-degree murder, this court has no other choice than to declare a mistrial.
During closings, the state argued that this shooting was the result of the defendant's premeditated rage.
Gentlemen, the defendant's not worried about Jimmy's history. He's had a good relationship with Jimmy. He's traveled with their family. He wants his own little girl to sleep in the same room Jimmy sleeps in. The defendant doesn't even have a relationship with Miranda Goddard that's longer than about a month. The use of deadly force was not necessary on Jimmy Shelton that evening. Maybe Sean Foley could have punched him in the nose. The evidence points that the defendant was lying in wait recording the interaction between Jimmy and Miranda in an attempt and in an effort to provide a justification for the shooting. He knew their history. Miranda had sent him inside so they could discuss the deal. He was possessive of Miranda, could have easily gone outside and refused to leave the two of them alone. If he thought she's drunk, he's drunk, this is a bad idea, I ought not leave them out here by themselves, he could have stopped this before it ever started. He did not stop it before it ever started. He let it happen knowing he was recording it with the intent to kill.
The defense argued that the defendant pulled the trigger only in self-defense after the victim came after him.
Sean and Jimmy had a normal relationship. There's no animosity there. There's no hate or angst or anything of the sort. What happened there? Something is different. Sean knew that Miranda was a sexual being, I guess is a good way to call it. They made sex tapes together, all that stuff. None of that matters. The question is, what happened through all that? Sean goes out there after he sees Miranda get pulled back down. Goes out there, says, "Stop." Threatens him. "If you mess with her again, I'll drop you." It's a threat. Okay? It's not intent. Still didn't kill. Then you hear the shuffle. You hear Mr. Shelton cross that porch, attacking my client, trying to secure that recording, because he just confessed to molesting her from the time that she was 12 years old. You heard her say that. He's going to kill my client. He was going to kill Miranda. He did it reasonably in self-defense. Himself or Miranda, or both.
Back to the panel for some last perspective tonight. Jessica Ramirez, Anthony Pope. So, Anthony, it's easy to get caught up in this soap opera of self-defense, molestation, all these claims. But at the end of the day, I thought about this after the verdict on Friday. The bottom line is the state just didn't have enough there for the premeditation. If the state can't prove it beyond a reasonable doubt, it has to be an acquittal, and that's what the jury did on the top charge.
Absolutely. That's the highest charge, and I think there was just some doubt in their mind, and they decided they were going to do the right thing.
Jessica, you're nodding your head yes.
I think so as well. I think the fact pattern was very chaotic. There were so many things going on. We know that there was sexual abuse. It wasn't substantiated, but there was some prior sexual abuse and investigation.
And a girlfriend who was back and forth on the witness stand about that as well, so that made it even more tricky.
Exactly. So I think that I think they got it right, and I had reasonable doubt. I didn't know what happened here, and I can understand where the confusion came. And I can see how he was trying to protect his girlfriend because there was sexual assault, and we got that from testimony and through prior investigations.
And that more critical part where the defendant said that he wasn't just trying to protect her, he was trying to protect himself because he said, and he testified, that the victim came after him. And in that split moment, look, the jury had a lot to unravel in this case, and they did. And we may have another trial coming up on that lesser charge. We'll have to see what the state does. That's all the time we have here on The Debrief. Our live trial coverage resuming tomorrow at 9 o'clock Eastern Time here on the network. The Debrief live with our recap at 5 o'clock Eastern. We'll see you then.